Good afternoon, Attorney La Viña. Thank you for joining us. What do you think are the hits and misses of the High Court's decision?
Good afternoon, Jess. I'm very happy with the first part of the decision of what has been released by the spokesman, by the office, media office of the Supreme Court. Section 4 and the clause in Section 4 has always been the most problematic provision in the anti-terror law because it seemed to expand terrorism to include, very ordinary acts of dissent, of protest, of even strikes were included, advocacy was included, and so it had a chilling effect on freedom of speech, freedom of expression, freedom of the press, freedom of assembly, and freedom of association. And we're happy, obviously, that the Supreme Court did heed our petition on this particular issue and has declared that provision unconstitutional. So that's not insignificant. That's a big win for the petitioners. It's a big win for many of our freedoms. But the way I frame it, this is a big win. Yes, this is an important win. It's a small win, but a meaningful one in a big defeat for human rights because the Supreme Court did uphold most of the anti-terror law, and we questioned many of those provisions. We obviously respect the Supreme Court's decision, but we do have a remedy, which is to file a motion for reconsideration for those provisions which we think should also be struck down. Now, we're happy it struck down the provision on other jurisdictions because we cannot really delegate judicial determination to a foreign body. But we would certainly want them to also prohibit the Anti-Terror Council to do that because the Anti-Terror Council is not a judicial body. We're concerned about the provisions on detention, on arrest, on freezing of assets, which we feel also do not, live up to the demands or the norms of due process. But we'll study the decision when it comes out. I mean, these are all first impressions based on a press release, and we'll, so that these are just initial reactions. And when we study it, we'll file the necessary motion for reconsideration. I'm one of the petitioners, counsels. I counsel for indigenous peoples and Moro peoples that filed their petitions here.
Now, looking at so far what we have on hand regarding the SE's decision is that at least for Section 4, it only struck down a particular part of that section. What does that mean? Does that mean that the rest of the section stands, and should that be a cause for concern?
Well, yes, that means it stands because if they nullify the whole Section 4, they have to nullify the whole law because then there won't be a definition of terrorism. Section 4 is a definition of terrorism. The first part of Section 4 is the traditional definition of terrorism, bombing, murder. We think even that is problematic because what it should have done was follow the Human Security Act, which first said that terrorism is committed through predicate crimes like murder, all of those crimes that are committed. And then terrorism is sort of the way you do those crimes and your motivation. But in any case, that's still the traditional meaning of terrorism, and that has been upheld. What has been struck down is the expanded meaning of terrorism because the court said it's too overbroad. And that's true, right? I mean, without this decision, a simple rally, a simple strike for economic dispute within a factory, a simple letter complaining to a government official about what the government official is doing, a press report that you can have, right? I mean, that you can have in your program that is about criticism of a public official. If those are all constitutionally protected activities, right? Acts. But if what you said leads to endangerment of an official or a person, leads to violence, even if it's not intended, but it happens. It happens all the time when you have a march, a rally, that there can be some kind of push and pull between rallies and officials. It can happen that your report as a journalist is completely innocent, but it can lead to endangering an official because you said something that might result in people being angry with that official. Then that becomes terrorism under the law, under the provision that was not struck down, under the original provision. Now there's no danger of that. You can blog all you want. I can tell people now, you can blog all you want. You can protest all you want. You can write a letter all you want. You can report as a journalist all you want. That won't be considered terrorism in itself. And that's what the Supreme Court did. And I really praise the Supreme Court. Justice Carandang, who's the main ponente here, is probably responsible for that. But it's a 12-3 vote, meaning to say the Supreme Court is very, very strongly, interpreted this in favor of civil liberty. So let's be very clear that this was a big victory. This particular decision has a lot of impact on thousands of people that might have been endangered by the anti-terror law in its original form.
Okay, given that, Attorney, which so-called draconian provisions will likely still be questioned moving forward?
For many of us that were petitioners, the main things we will be questioning would obviously be the provisions on detention, extended detention, 24 days detention, the provisions on designation by the Anti-Terror Council, which we feel do not follow respect due process. Obviously, provisions related to that are the freezing of assets of some organizations that really are not terrorist organizations, but are just helping out people. So yes, there'll still be several provisions that still need to be questioned, and we hope the Supreme Court will take a second look at it when the motions for reconsideration are filed.
Okay, given that, do we assume that there will still be further challenges here regarding the SC ruling? How far are you willing to take it?
Yes, for sure. We will be filing a motion for reconsideration when we see the decision and study it. As I said, what I'm happy about is that the decision declaring the proviso in Section 4 unconstitutional is a strong vote, 12-3. So the likelihood of it being reversed is probably small. I'm happy for that. But we still have to work to convince a majority of justices on the other provisions.
All right. Thank you very much for your time and insights, Attorney Tony La Viña.